4. 4 is the amount of Second Amendment cases that the U.S. Supreme Court has agreed to hear in its current term, because today the U.S. Supreme Court agreed to hear a 4th one. That's right, we're talking about Vanderstok case. This is the frame receiver rule. This may sound obscure, but we all have a stake in this. We're talking about privately manufactured firearms, PMFs, i.e. those scary ghost guns, but mainly we're talking about the ATF, the Gun Control Act of 1968, and you all need to be paying attention to this, even if you don't give one rip about ghost guns, because guys, the same tactics and legal tools used to conquer this issue for the gun controllers will be used later on. So guys, let's get into it. All right, so we're going to give you the low resolution, which should give you a little bit of the roadmap so that when I start drilling into the details, hopefully you'll be able to follow it a little bit faster. So in order to understand what's going on here, let's go back to 2022. That's when the ATF announced the new rule dealing with frames and receivers. Stay with me. Basically, this deals with the question of what's a firearm, legally speaking. Now, the ATF contends then, as they do now, that the statutory definition, when we are talking about statutes, we're talking about laws that are enacted and passed by Congress. So, laws, not ATF administrative code interpretations, laws. Now, the ATF is saying that the congressional law, that definition passed by Congress as part of the Gun Control Act, the GCA back in 1968, it's simply out of date and it needs to be cleaned up in the name of good public policy. Now that's code for gun control, among other things. Now the Firearms Policy Coalition, fantastic group, along with GOA, SAF, National Association for Gun Rights, and so forth, all deserve your support. But the FPC, the Firearms Policy Coalition, filed a lawsuit in the Northern District Court of Texas seeking to vacate, that's code for just destroy, delete the final rule. And they got a judge to agree with them, who basically paused most, but not all of it. Details on the sections not paused, linked in the description box below when we did a video covering that. For now, we're keeping to the essential issues here. The essential claim, among others, was that while the government agencies are allowed to interpret laws passed by Congress, okay, that's what they can do, they cannot exceed what is written by Congress, as the ATF has allegedly done here, according to the FPC, and I'll add many others, including myself. Now, the long short of this compressed version is that the FPC won in the federal district court. That's the federal trial court, and the rule was vacated. This was then upheld by the Fifth Circuit. Remember, we go federal district, that's the trial courts, and there's 13 federal circuit courts, and then to the U.S. Supreme Court. Those are the layers here. This was upheld by the Louisiana-based Fifth Circuit, which also oversees Texas and Arkansas. But the Supreme Court stepped in and basically reinstated the rule pending the outcome of the case. In other words, guys, you keep fighting this out, but this rule will remain in effect until we have had a final say on this, should it ever get back to us. So that's in essence what happened, which is the reason why you may be hearing about the fact of, hey, FPC and the groups that are on our side, the groups that are on the Second Amendment side, they keep winning the battles, but the rule doesn't seem to change. That's the reason why. That came from the U.S. Supreme Court, who has said that it might change eventually, but it's going to remain in place until we have had a final crack at it. So we're not back at the Fifth Circuit Court of Appeals. We're now up to the U.S. Supreme Court. That's where this has officially been appealed to. And both sides, both the FPC by way of Vanderstok as well as the Biden administration, have said this case needs to be heard. And today, April 22nd, 2024, the U.S. Supreme Court said, yeah, it does. And now we've got our 4th case going to the U.S. Supreme Court right now. And I think there's a 5th one that's going to be on its way. I'm going to predict, as I've said before, both about this one, which is now fun to be right on. But I also think, and we'll go on record repeatedly once again, that I think that the so-called assault weapons ban, as well as the so-called high-capacity magazine, i.e. modern sporting rifles, normal capacity magazines, I think that there's a good chance that the U.S. Supreme Court will be hearing those issues thanks to the lawsuit coming out of Illinois and the Seventh Circuit. covered in other videos before. But I think that that's where the rights and the battles over capacity magazines of 10 and up, plus AR-15s and so forth, I think that's where that's going to be getting fought out. So I think there will be a fifth case going. And I will briefly at the end of this video give you a couple sentence description of each one of these issues on each one of those 3 other cases. So stick with me to the end. Really quick, low resolution on that. So what's the slightly higher resolution? No, this will not be an ambient video that's going to knock you out and put you to sleep. Hopefully, you know I don't do that, or at least not intentionally. But let's just take this one cut more for the people who always say in the comment section, I want more. All right, so we have to go back to the Gun Control Act of 1968, which regulates the firearms in interstate commerce. Under the GCA, Congress granted to the Attorney General the power to prescribe rules and regulations necessary to carry out the Gun Control Act's provisions. That's not by any stretch uncommon, okay? There are 400 and some odd, I think 434 off the top of my head, federal agencies and sub-agencies. This is what they do. It's the fourth estate. There's a lot to not like about that. This isn't the video to talk about that. It just is what it is for right now. Yes, ATF cannot pass laws. I know. I will still see that comment. That's okay. Now, the Act, the Gun Control Act, defines the term firearm basically in 4 different ways. And you can find that, by the way, in the description box below. Not going to go into all the details right now. Then in 1978, the ATF, which back then was still reasonably young, promulgated a rule interpreting the phrase frame or receiver. Now, the ATF has done a really good job to their credit of coloring within those lines of the 1978 rule. That is, until April 2022, when the ATF published a final rule changing, among other things, because again, not the only things that they did, it's just what we're talking about right now, the 1968 definition of what is a frame and what is a receiver. Now, the rule took effect back on August 24th of 2022, and the ATF split the phrase into 2 parts, assigning the term frame to handguns and the term receiver to any firearm basically other than a handgun. So we're talking about rifles, shotguns, and a couple of obscure other things that are out there. The ATF then defined the terms frame and receiver along largely the same lines as the 1978 rule, although with updated, more precise technical terminology. The issue is that the ATF did not stop there. But I'm going to take a quick pause to let you know that if you just found us while browsing through, don't forget to hit that like, subscribe. Of course, join the discussion down below. Where do you think the U.S. Supreme Court is going to be going on this and the other cases? I also would like to see a rank ordering. Again, I'm going to give you all those cases at the end. What do you think is going to be the most important cases? And they're all important. I know that. But they're probably not all equally important in a lot of your minds. How do you think they should be ordered, and where do you think the U.S. Supreme Court is going to go on this and others? That's going to be the discussion, and let's keep going with this. So rather than merely updating the terminology or, having Congress change the law, if that's what's actually required, which is what the ATF and the gun controllers are basically saying the ATF is forced to do, which is ridiculous because that's what Congress can do. But ATF decided to regulate partial frames and receivers. So incomplete, not there yet, under their new final rule. Quote, the terms frame and receiver shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed or maybe readily be completed, assembled, restored, or otherwise converted to a function as a frame or receiver. The terms shall not include forging, casting, printing, extrusion, on-machine body, or similar article that has not yet reached a stage of manufacture, but is clearly identifiable as an unfinished component part of a firearm. So in other words, a uniform block of metal or liquid polymer or other raw materials. Okay, so that's theoretically what it shall not include. But when determining whether an object is a frame or receiver, the ATF director is not limited to looking only at the object itself. Quote, when making a classification, the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or possessed with the item or kit, end quote, and it goes on from there. What's the problem with all this? Well, as one of the judges wrote in one of the decisions here that has come out of this whole legacy of this case, quote, the final rule is limitless. It purports to regulate any piece of metal or plastic that has been machined beyond its primordial state for fear that it might one day be turned into a gun frame or a gun receiver. And it doesn't stop at regulating the metal or plastic until it's melted back down to that ooze. The Gun Control Act allows none of this, and the judge went on to add that I concur in the majority's opinion, holding the final rule to be unlawful. Another interesting quote, an agency cannot label conduct lawful one day and felonious the next, yet that is exactly what the ATF accomplishes through this final rule. That's page 28, by the way, from the Fifth Circuit Court of Appeals. There's basically two issues I just want you to focus in on. We're talking about ATF power, about how they're not just clarifying an existing rule or law, they are transcending it. And that's what certainly FPC and all these other groups that have been suing and up in arms is about. Administrative agencies are well within their power, for right or wrong, better or worse, to interpret the rules. But they cannot clarify the rules to the point that everything just is completely changed, let alone it goes beyond the statutory power outlined by Congress when, they actually pass the law. You can interpret the law. You cannot make new law, which is effectively what the ATF is doing here through this rule. And of course, the other issue is just, when is a gun a gun? So if you take a hunk of aluminum and you make slight machining cuts, and God forbid somewhere in your house or whatever it is, you've got a jig, a mold, you watched a YouTube video once upon a time or whatever, and now you've arguably entered felony territory. That's unfortunately a slippery slope, which I understand someone's going to say is a logical fallacy, but here we are, 2024. You look up slippery slope, you see the ATF. I mean, that's just what it is. Really quickly, what are these other cases? Maybe for some, the least exciting one is a case called VULO, V-U-L-L-O. That's one where the NRA sued the head of the New York State Department of Financial Services, which was a regulatory body that looked over insurance regulation, all this other kind of stuff. The department issued a non-binding guidance memoranda to banks and insurance companies, encouraging them to, hey, monitor your risks, including reputational risks that may arise from doing business with the NRA. Now, the NRA claimed then, as they do now, that the guidance memos constituted regulatory threats that resulted in the NRA being dropped by its longstanding corporate insurance carrier. So, too long did not read. This is, according to the NRA, what New York State did. They walked in, they looked at all these different banks and all these different companies that they regulate and they've got power over, and they said, hey, if you do business with these guys, I'm just saying, don't not do business, but you got to watch your corporate risks, if you know what I'm saying. That's in essence what's going on here. Okay, so that's VULO. It's fundamentally a First Amendment case about the Second Amendment, and of course there's more to it, and we've covered videos on that before. Rahimi, who we've already heard the oral arguments on, I think back on November 6th, if memory serves. This deals with the question of who are the people in the Second Amendment. The right of the people to keep and bear arms shall not be infringed. Who are the people? Included are the people, perhaps, are they folks who have misdemeanor crimes of domestic violence, domestic abuse injunction orders against them? Do they have felonies against them? We'll see what the scope of that lawsuit is. We've covered this many times in other videos. The gist of this is Rahimi was a prohibited possessor under the law due to domestic violence injunction against him. So that's the specific issue in that case. Rahimi, by the way, not a good guy. Won't cover it all here. You're not going to like him if you look him up. Just not a good guy. So it's a bad fact pattern, and I'm worried about what we're going to get out of that. But fundamentally, we're going to see some framework to the question of who are the people in the Second Amendment. And then, of course, we've got Cargill v. Garland. This is the bump stock case. We're dealing with Chevron defense in that case. So Chevron defense is basically the doctrine that theoretically courts should give deference to administrative agencies like the ATF when they make interpretations such as this is a machine gun, that's not a machine gun. Oh, never mind, it is a machine gun. That's a big part of that case. We've covered that extensively elsewhere before. But we've got VULO, we've got Rahimi, we've got Cargill, and now we've got Vanderstok. Rank them in the comments section. How do you think they're going to turn out? I'm worried about Rahimi. I'm feeling a little bit more bullish on VULO and Garland and Vanderstok even. I think it's interesting that Vanderstok has gotten to this point. The U.S. Supreme Court did put the stay on this. That's what has me worried about Vanderstok. We're going to have to see what happens. Let me know what you think down in the comment field below. And we're going to close out with our ever popular quote of the day. This one comes from the ancient Chinese thinker and philosopher Confucius. Quote, "He who learns but does not think is lost. He who thinks but does not learn is in great danger, end quote. All right, and just a fun little extra tidbit. Did you know that Confucius didn't even speak English when he wrote that? Whew. Wow. This is why you come to the internet, for insights like that, right? Don't forget to hit that like button and comment down below. Look forward to joining the discussion. Back to you guys. We'll see you next time. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.